Hi, we're going to have a look at some of the elements of civil or tort law in this lecture. Some large areas, but we'll try to keep it as simplified as possible. So we have to look at the tort of negligence, occupier's liability, and misrepresentation. And we'll touch upon some other factors as well. So negligence, it's a sort of fundamental area of civil law that just about everybody, I guess, really needs to know how it works. It's based on the concept of duty of care. This is sometimes referred to as the neighbour principle, an idea that as you go about your activities, you should be careful in the sense of not to injure other people who we might consider as your neighbours. The duty of care, there's different ways of looking at it and classifying it, but this is how I'm going to explain it for you. We could have what we call the common duty of care. As I say, that's just basically your neighbour principle. The notion that you have a duty to everyone you come into contact with. It's set out in a really famous case of Donoghue against Stevenson from around 1932. In that case, the court really set out the whole idea of it, the common duty of care, and the element of negligence. And that case was followed afterwards by other cases, and we might just look at the Grant case as well. So in Donoghue, a lady went and bought some what was described as ginger beer. She was out having a meal with her friend, and they drank some of the ginger beer with their meal. I think it was used maybe in a dessert, making like an ice cream float or something off the top of my head. And in the end of the bottle, as they poured out the remaining contents of the bottle, a decomposing snail slid, I suppose is the best word, slid out of the bottle onto the food. And Mrs. Donoghue was taken quite ill. She was quite repulsed by this, and she was sick, and so on. And she brought a case against the retailer and the manufacturer based on this idea of a breach of duty of care. Obviously, there was a direct connection between Mrs. Donoghue and the retailer because of breach of contract. There wouldn't have been any contractual relationship, any direct one between Mrs. Donoghue and the supplier of the ginger beer because she had no contract with them. That contract would have been between the retailer and the supplier. But she successfully argued that the manufacturer of the product owed a duty of care to the ultimate consumer, who in this case was her, to ensure so far as possible that, or at least reasonably possible, that she wouldn't suffer an injury, basically due to their negligence. So she was successful in that case. And if we look at a case that was around the same time, it fell under the Commonwealth jurisdiction of the court, so it would have been in Australia. Such a Dr. Grant bought some underwear described as being long johns, and he wore the underwear and he suffered severe dermatitis. He had a very bad rash and an itch in areas that we don't want to get into. Just suffice to say that it extended down to his ankles. As he was a doctor, he went off looking into this, and it turned out that the cause was an excess of sulfites in the actual underwear itself, and these could easily be rinsed out during the manufacturing process. So he brought his case, and based on the same principle, the manufacturer had a duty of care to Grant to make sure that he wasn't injured by the underpants. So that's, the idea that everyone owes a duty of care to others. Sometimes the specific duty might be more than sort of reasonable care. It may be specified in statute. So we'll be looking at the Occupier's Liability Act. So for example, there's a duty there for trespassers that's classified as reckless disregard. So the legislation specifies the statutory duty of care. And then you might have additional duties that you've promised to do things in a contract. So you have that direct contractual relationship with someone. So, for example, in a building contract where maybe the contractor promises to do the work to a good and workmanlike manner. If he fails to do so, he's in breach of contract, but you may also be brought to court for negligence as well. So it's common enough that a particular case involves both tort and contract law. So the essential elements then, obviously you have to create the existence of the duty of care, which may ultimately just be the common duty of care. The duty can extend to a lot of different parties. So if you think of something like a house, well, you have purchasers, you have investors, you have banks issuing loans, and so on. So it's not, as I say, always that obvious in terms of being a direct connection to a party. Similarly, instances where somebody maybe was doing excavation and caught a power line, that could result in a factory not being able to operate, which would result in a substantial loss of profits. So the question is, was there a duty of care in the first place? Was it broken? And then was it be reasonably foreseeable that that loss or damage would occur? Obviously, some damage or loss must be suffered, but the key area then to focus on after that is, was it reasonably foreseeable, and what does that mean? So that's a weighing up exercise, really, using this objective test of reasonableness. Would a reasonable person, if they were approaching traffic lights and saw that they went orange, would they prepare to stop, or would it gamble and try and get through? And if they were in a crash after the fact, with hindsight, we would be looking back saying, were their actions reasonable? What would a reasonable person have done in the circumstances? So, for example, in the Bolton case, where the lady was outside her house and a nearby cricket ground was situated near where she lived, and someone struck a cricket ball and went out over the perimeter fence and hit her. Now, I'd imagine if you got hit with a cricket ball in the head or something, it'd be pretty painful. They're solid objects. But this had never happened before. So, what were the chances of someone clearing the perimeter fence, number one? And then number two, if they did, what are the chances of pinpointing to one individual that might have been passing by or out in the street or whatever? So it was held in that case that that her injuries weren't reasonably foreseeable. We can contrast that with another case of Parsick and Stepney Borough Council, where a guy was working on a road sweeping truck and he was hammering at something underneath, and a piece of metal came off and struck him in the eye, causing loss of sight. Management were asked why he didn't have safety goggles, and seemingly the reason he didn't have safety goggles was because when they were giving out safety goggles, they didn't have enough for everyone, and poor old Mr. Paris already had only one eye. He'd lost the sight in his other eye during the war, World War II. So some bright spark thought that the fact that he'd only one eye made him less likely to get hit in the eye, because he'd one rather than two. We shouldn't laugh, but it's a bit of a strange one. So obviously, if you were exercising reasonable care towards your employee, even in advance of all health and safety legislation that's there today, you would be inclined to try and provide them all with goggles, and I'd say that regardless as to how many working eyes they had, be it one or both. So reasonably foreseeable. It depends on the circumstances and what a reasonable person would have done in the circumstances had they been in the say defendant's situation. So yeah, one of the things that arises a lot then is around negligent misrepresentation, which also comes up in contract law. There are two things really, or arguably, a misrepresentation and a misstatement. In contract law, we often specify about misrepresentation, a representation being a pre-contractual statement. That's one of the factors that causes somebody to make the contract. So if you think of a salesperson selling a car, saying how fast the car goes and so on and so forth, if it's a statement of fact and that statement of fact turns out to be false, then that can be viewed as a misrepresentation, which will have an effect on the contract. Obviously, if somebody doesn't check the accuracy of that false statement, then it's likely to fall under the breach of duty of care and negligence idea. A misstatement, one could argue, is slightly different, although the courts tend to treat them in the same and consider them to be much the same thing. A misstatement, we could argue, is more of an advisory statement. So, for example, you might seek advice from one person to deal with another. So in terms of the types of statements, a certification statement, say certifying works in construction or in business, if you take maybe an accountant or an auditor certifying statements of accounts, it's quite a serious responsibility. Or, you go to your financial advisor and they advise you about, investments and so on to make. So those advisory statements, if they turn out to have, I suppose, not being properly looked into and checked out before they were issued, could lead to a claim for negligent misrepresentation or misstatement. In terms of negligent misrepresentation, one of the leading cases would be Hedley, Byrne and Heller. What's interesting about that case is advice was given as to the creditworthiness of a company, and that advice turned out not to be very sound. And a claim was brought for negligent misrepresentation. But as I say, it's quite an interesting case because ultimately it didn't matter, as the issuer of the statement had put in a little disclaimer, if you like, saying that their advice was issued, quote, without responsibility. That meant that even if their statement had been negligent, it couldn't be acted upon in a court of law because it was issued without responsibility. So I guess if you think of, someone coming up to me asking me to give a reference for a student, then ideally, it's possible that, do I remember the student? How often were they in the class? So something, might start off that reference with during the time the student was in my class or during the time the student was known to me. But, ultimately, the reference wouldn't be any good if I said, well, I think they'd be a good employee, but don't take my word for it. Don't hire them based on my recommendation. That defeats the purpose, really, of giving the reference. There's also a case of Forshaw against Walsh involving a Lamborghini, where there was a Lamborghini, and a number, I think possibly around 11 off the top of my head, Lamborghini Diablos that this lady wanted to buy on behalf of a business. I presume they were going to be company cars or something. They'd be very nice ones too, Lamborghini Diablos. I think they're the ones where the door opens up the ways. But in any event, she went to a garage in Ireland and they said that there'd no problem, they could find her Lamborghinis. They come up with a price and a deposit, which, as you can imagine, was a lot of money. She then went to the bank and said, before I lodge this deposit, is this garage trustworthy and so on? Should I deal with them? Are they good for what they're claiming? And the bank said, oh, yes, they are. Lodge the deposit with us. As you can imagine, this garage actually couldn't get her the Lamborghinis. And she had now lodged, I think it was over 600,000 or something in it as a deposit. So the money's not particularly relevant, but I think that's what it was. But ultimately, she brought a case against the garage for negligent or for fraudulent misrepresentation on the basis that they lied about being able to get the cars, and against the bank for negligent misrepresentation for their advisory statement that the garage would be good for their promise. So anyone involved in any kind of profession, be it solicitor, accountant, quantity surveyor, architect and so on, needs to be very, very careful about advice and advisory statements that they give or anything that they certify. And there are a few other factors I'd mention around negligence. And again, you can read around these in your course notes. Um, one is causation, or what we refer to sometimes as the chain of causation. That is, the defendant that you're bringing the claim against must have actually caused the loss. So there should be no break in the chain of causation between the action that they did and their final resultant injury. So it's supposed to be like if you came across someone on the side of the road with a neck injury and you decided to throw them in the back of your car and drive them a couple of miles to the nearest doctor. How can we be sure that whoever pushed them or struck them or whatever caused their neck injury, or that you didn't cause it or make it worse during transit? So always check the chain of causation. There's a Connolly case involving a captain of a ship who brought people out, or a boat, who brought them out in a boat, even though he had been told that it wasn't safe to do so. And the question arose as to whether it was the manufacturer's fault or the captain's fault. And obviously, the boat was entirely safe where it was. It was his decision to bring, a boat that wasn't seaworthy out on the water, and ultimately causing the loss. Barnett there involved someone showing up at a hospital feeling unwell, and they were sent home and told, Josh, if you're not well, come back in a few days. And then they were dead pretty soon after. It turned out they were suffering from arsenic poisoning when they went in initially. However, as this wouldn't have been detectable, and even if it was detected, they wouldn't have been able to save the deceased. Then it was held that the hospital couldn't be accused of actually being the cause of the loss or contributor to the cause of the loss. Speaking of the word contributor, another element of negligence is contributory negligence. Here, the person who's been sued says it's not entirely my fault, it's partly your own fault. If you weren't looking where you were going, that sort of idea. So, how this works is there's an apportionment of liability. In other words, you divide up the loss. So you say the defendant is 75% responsible, for example, which means that the plaintiff bringing the case was 25% responsible themselves. So you then calculate what the entire loss would be in money terms, in terms of compensation, and then you reduce it by 25%. And it could be 50-50, 75-25, or so on. It's just splitting it up. So case law examples, there's Boyne against Bussall Clea, where a person in a drunken state got off the bus, fell in front of the bus, and the bus driver drove over their leg. And that person would have been contributory negligent because obviously with their drunken state and so on contributed to their injuries. The McDonough against case was involved in an excavation around King John's Castle in Limerick, and someone fell into a trench, but it turned out that they'd fallen into trenches several times before, and they could have walked around to the other side instead of reaching across the trench. So they were contributory negligent, but the defendant was also negligent because they didn't shutter or slope the sides of the trench, which would have been good practice. Professionals are judged by a higher standard of care than ordinary people, and therefore we use the expression professional negligence. There may be issues for example, if a professional is doing work for free, what's known as pro bono or good faith work, as to whether they should be judged by the same standard. In any event, professional negligence is quite difficult to prove because you need another expert, obviously, to come in and say that the professional was negligent and didn't exercise the correct standard. Vicarious liability is a type of liability that says an employer is liable for the negligent acts of their employee. Obviously, these generally relate to things that the employee did during the course of their work. So there is a case where a guy was kicked by a bullock. He was kicked in the scrotum, which sounds like a nasty injury, potentially, anyway. And he brought a case, and he said it wouldn't have happened if there was anybody in the ring with the bull or Bullock, I should say, at the time. It happened in the Mart, I think, the local Mart. He had two helpers, but they weren't instructed to go in with him. So he said it was an injury in the course of his work, and his employer should be liable. There's another one where a guy threw a stone at a cow and hit a passerby. There's one involving a security company where the security guard was telling the thieves when to come in and steal the stuff from the yard. There's one involving a milk lorry round where the guy got a kid to help him, which he shouldn't have done, and the kid got injured in the course of the milk round. And there's one where a guy was in a car crash because he decided to go off on some other route, nothing to do with his normal work route at all. And in cases like that, it is arguable that what the judge described as somebody going on a frolic of their own, off their own bat, not particularly related to what they're supposed to be doing for work that day, that might amount to something that you wouldn't be vicariously liable for. And I suppose, look, employers are very careful, and even you think of some basic stuff like social clubs, Christmas parties. These days, employers don't organise any of those things. Even some of those kind of team building work days, weekends away, employers are very careful, I think, nowadays around anything that would reflect on the company itself. And obviously something that the employees might do or get up to. I won't mention certain Christmas parties in Ireland in recent years, where there seemed to be a lot of media coverage afterwards, that is reflecting on the business, and ultimately it may be vicariously liable for the employer and also reflect badly on them. So another thing is the limitation of actions. In general, for simple contracts and for torts, your claim has to be made within 6 years. For personal injuries, it's set out in the statute of limitations as amended as 3 years. And one of the things you've got to be particularly careful are what are called latent defects or hidden defects in a building. They may not be obvious at the time the work is done or the contract is done or completed. So it's said with latent defects that the time only begins to run when the defect manifests itself, which is often described as being when the defect is recoverable or discoverable. There's an Irish case, a good Irish case, O'Donnell, on it, where he wanted to change windows in his front of his house, and there were cracks. And he'd already pointed out about cracks some years earlier to the contractor, and they said there were settlement cracks. But his engineer did some investigating, and it turned out that these particular cracks under the bay window were caused by an excess of iron pyrite in the concrete blocks that were used in the construction. So when he went to bring his claim, the contractor said, "Oh no, you should have brought your case within 6 years. You're too late. It's too long ago." But his argument was that these particular defects had been latent or hidden, and they only manifested themselves at a later stage, which would have been within 6 years from the date of manifestation, and he was successfully able to claim for negligence, although he may not have been able to claim for the breach of contract under the 6-year rule. The occupier's liability then, it's always worth looking at some of the definitions, like what's a premises, because it covers all sorts of things like boats, airplanes, vehicles, land, buildings, and so on. And who is the occupier? It's not necessarily the owner at a particular point in time. It's the person, if you like, who's in control of the premises. And bear in mind that premises has a lot of possible meanings. The Act sets out the duty of care to either visitors, recreational users, or trespassers. The duty to visitors is a duty of reasonable care, so it is essentially the same as the duty in negligence. In the Devil's Glen Equestrian Centre case, Sheehy fell over a weather bar on the way into the equestrian centre, because it was sticking up out of the floor a bit. It was a bar to stop rain and stuff getting in under the door and drafts. She fell over it and sued and won, because it was argued that the design could have been done in such a way that this wouldn't happen. So even though they argued she should have been looking where she was going, she wasn't even found to be contributory negligent. Another, I suppose, interesting case is the Power case, where Power fell in the bathroom in a prison and got compensated for his injuries on the basis that, the type of tiles you use on the floor in a bathroom in a public type place or communal place and so on should be anti-slip, easy to see water on them and so on. Got something in around €16,000, I think, in compensation, but the figure is probably mentioned in the notes. Again, the sum of money is not important, except it just demonstrates the seriousness sometimes of these things. The duty to recreational users. A recreational user is defined as somebody who's engaged in recreational activities. So hill walking, that sort of thing. So there's a Trabolgan case where a lady was at a Trabolgan leisure facility and she was traversing along a muddy path with probably not the best grip footwear, carrying a child on her back, and she slipped and fell and suffered some serious injuries and sued and won. In Weir Rogers' case, the lady was sitting on the edge of a cliff. She stood up to leave and she fell over the side down onto the rocks below and suffered some very serious injuries, as you can imagine. In the High Court, the occupiers of the land were held to be responsible for her injuries, but it was appealed to the Supreme Court, and the Supreme Court said that the only person who didn't act with regard for her safety was actually the lady herself, and that she should have realized that it was an obvious danger. If something isn't an obvious danger, however, you would have to warn people of it, such as recreational users. So, for example, the Copper Coast here in Waterford, if you drove the Copper Coast from Tramore, say, to Dungarvan, there's a few places, parking places, and there's signs up beside some of them warning people of the mine shafts in the area and that the ground is likely to subside and so on, because that wouldn't be an obvious thing. It doesn't appear everywhere. So that's the recreational users. Again, care would have to be taken in general with visitors and recreational users and so on, particularly visitors around persons suffering disabilities and children. And obviously the people in control of those individuals should also exercise care, but normal signage and so on may not work as effectively when dealing with minors and children and persons with disabilities. So just to be careful there. And then finally, we have trespassers who are neither visitors, as in they don't have permission of any sort, or recreational users. And the test here is not to act, again, with reckless disregard for their safety. So it's a lot more than reasonableness. It'd be like having a big hole dug in the ground without any cover or signs or anything. So it's almost like a trap for the unwary. The cases on it would include Williams against T.P. Wallace, where Williams came across from Scotland to inspect guttering that an Irish company had been complaining wasn't fitting correctly to a building. Williams went off and found a ladder on site, went up on the roof to look at the guttering, and then fell on the way back down. Hadn't informed anyone that he was coming or anything like that, sort of surprise visit. So the court felt that the only one who acted recklessly was Williams himself in going up on the roof, and that in fact he was a trespasser and not a visitor. And also health and safety rules didn't apply to him as such, in the sense that he was trespassing And it wasn't the case that the ladder was there standing against the building already. He actually went off and got the ladder and came back and set it up incorrectly without it being properly secured. Tomlinson was about a young lad who went to a quarry. It's an English case, and they had signs up everywhere: no diving. Some things like canoeing, I think, might have been allowed, but they were particularly strict about no diving, as it was quite dangerous with underwater rocks. But Tomlinson dived in somewhere and injured his neck. And he wasn't considered to be a visitor due to the signage, as he wasn't meant to be there and doing what he was doing, so he was considered to be a trespasser. And again, it would be argued that Tomlinson acted for disregard for his own safety in diving in a place where he shouldn't have, rather than the quarry occupier being liable. So sometimes the question is asked, what about someone who breaks into your house to commit a crime or whatever? And generally you would have no liability. However, it does come with a proviso that presumably you'd have to show that they were there for the unlawful purpose. Otherwise, they would just be considered a trespasser, and you would have a duty, albeit the duty of reckless disregard. It's worth looking at the difference between occupiers and activity liabilities. The occupier's liability relates to the state of the premises. For example, an uncovered hole in the ground, as we said earlier, or a wall collapses, or a roof, maybe possibly shelving in a retail place, or the way stuff might be laid out in the dining room in a hotel, for example, or absence of lighting in certain areas, even including maybe on an airplane, for example. So the activity liability then refers to the activities that are actually going on the premises. So on a construction site, there's going to be site traffic, vehicles moving around. In a hotel, there's going to be waitresses and waiters carrying, hot tea, hot stuff. In a shop, you're going to have people moving around stocking shelves. So if the injury is caused by the activity, then that's, strictly speaking, a negligence claim and not an occupier's liability claim. There's a case on it, and a Fairchild case, where contractors are removing asbestos from a building, and some of it got airborne, and asbestos is extremely dangerous. Certain types of it causing asbestosis. So the question arose as to who would be responsible for a person getting asbestosis, and it was said that the asbestos was part of the building, but it was completely harmless in its dormant state. It was only the process of removing the asbestos that would create it to go airborne, and as that would be carried out by some independent contractor, then really that would be a negligence claim against that independent contractor, and not an occupier's liability claim against the occupier. And just to mention, there was just on the last slide about using signs to reduce the liability that you have to visitors from reasonable care to a lower standard, such as reckless disregard. So you will see signs warning people of entering premises and dangers, even standard ones on a farm gate or gate into a farmyard. So a good bit there. So make sure you read over the material. You can divide it into chunks probably a little bit in terms of the notes available, or if you're looking at a textbook or anything like that, where one was suggested. So other than that, that's a good part of Tort covered there.